Sir, District Magistrate Rajouri has issued an order whereby he has placed under suspension a member of Jammu and Kashmir Administrative Service. But the reports are coming that it is said that the Jammu and Kashmir High Court has pronounced a judgment whereby it has declared that the Deputy Commissioner is not authorized to suspend a member of IS and JKAS. So please enlighten us that how come the performance of district magistrate, how he pronounced this order and how come this exercise was performed by him under the law.
Let me apprise you that the Honorable Division Bench of the J&K High Court on 11th of February 2021 in case titled Kaisar Mahmood versus Union Territory of Jammu and Kashmir has quashed an order passed by the Central Administrative Tribunal Jammu, whereby the Central Administrative Tribunal had failed to decline the stay, had failed to grant the interim relief to a member of the J&K Administrative Office, J&K Administrative Service, who was serving as Tahsildar Badi Brahmana and was placed under suspension by Deputy Commissioner Samba. Let me apprise you what were the facts of those cases. That Mr. Kaisar Mahmood, an officer of 2012, this JKAS batch, he was serving as Tahsildar Badi Brahmana, and there was some civil litigation going on between the parties, wherein the Tahsildar Badi Brahmana was not a party at all. There was some issue with regard to the implementation of the court order, and court had not directed the Tahsildar Badi Brahmana to enforce the order of the court, but the party concerned complained against the Tahsildar to the Deputy Commissioner Samba, and Deputy Commissioner Samba immediately placed Mr. Kaisar Mahmood Tahsildar Badi Brahmana under suspension. We challenged that order. We challenged that order before the Central Administrative Tribunal, and we took two grounds. Twin grounds were taken before the CAT Jammu wing. First is that under Rule 31 of J&K CCA rules, means J&K Civil Services Classification, Control and Appeal rules, it is only the appointing authority which is competent to place a government servant under suspension. A appointing authority or an authority superior to the appointing authority, or an authority which is specially empowered by the government to initiate disciplinary action against the government servant. Our second contention was that the government has issued an SO, means an SRO, in October 2019, whereby it has been clarified and directed to all the administrative secretaries that before initiating any action against a member of All India Service or Kashmir Administrative Service, the file has to first go for approval to the Honorable Lieutenant Governor through Chief Secretary. So we were having two contentions. First, that the DC Samba is not the appointing authority, nor he is authorized, not he is superior to appointing authority, not empowered by the government, and there was no approval obtained from the competent authority, that is the Honorable LG. The Central Administrative Tribunal did not agree with our contentions and declined the interim relief. Against that, we approached the Honorable High Court, and in the Honorable High Court, we reiterated the grounds which I have already submitted. A division bench of the J&K High Court, comprising Justice A.M. Magre and Justice Puneet Gupta, in a very, I will say, authoritative pronouncement on 11th of February 2021, titled Kaisar Mahmood versus UT of J&K, quashed the order of the Central Administrative Tribunal, and the J&K High Court division bench framed the moot question that whether a deputy commissioner of a district can place a member of the JKAS, Jammu Kashmir Administrative Service, under suspension. The answer was no. This judgment is a final word with regard to the powers of the deputy commissioner, and with humility at my command, I would respectfully submit that the deputy commissioner, the DDC Rajouri, he has exceeded his limits. He has exceeded his jurisdiction. This order is legally bad, unsustainable, and it is required to be set aside.
Now, sir, even if a member, that means a deputy commissioner, gets the approval of the competent authority, is it mandatory to mention all this that he has been granted approval by the competent authority? Is it mandatory to mention in that very much order?
Sir, everybody has gone through the order passed by the Deputy Commissioner Rajouri. There is no mention. The suspension order is not happily worded. He has simply mentioned about the allegations of the complaint. There is no reference of the approval obtained from the Honorable Lieutenant Governor in coordination through Chief Secretary. There is no reference of any approval obtained from the appointing authority. So, with due respect, I would submit this order is prima facie in violation of Rule 31 of J&K CCA rules and the SO of 2019 October, which was issued by the government, which specifically says that before initiating disciplinary action, the approval of the competent authority, that is with regard to the members of the All India Services and Kashmir Administrative Services, the approval of the Honorable LG through Chief Secretary is mandatory.
Sir, one last question. Despite the fact that a division bench of the J&K High Court has already declared that a deputy commissioner is not authorized to suspend a member of IS or KS, but still an order has been issued by the district magistrate Rajouri. So, on the legal point of view, I would like to know that what action becomes, maintainable against the deputy commissioner who has issued an order against the judgment of division bench.
I would like, as a student of law, I would say that the deputy commissioner may not be having the knowledge. He must have, I think, the nature of the controversy. I think hurriedly, on some political pressure, this order has been issued. But the deputy commissioner, after watching this and after knowing about the law of the land, he should immediately resign and he should immediately withdraw this order.
Thank you, sir. Thank you so much for giving your precious time and speaking with us. Thank you so
Thank
much.
you.